Welcome back, everyone, to the LawCast. I am Chris Decentine, and this is Melanie Thorley. We are both solicitors here at MJTlaw, and we're back for another week in another instalment. I know you've been doing quite a lot of scribbling away about a topic that you're hold dear, certainly, and one which is quite interesting.
It is. This is today's podcast is all about solicitors behaving badly, and. Look, I know that there's, a lot of solicitors out there and most of them, 99.9% of them do not behave badly.
No.
But when they do, it is wild.
Yeah. I mean, there's plenty of things on popular media about lawyers being sharky and,
liars for a living and all that sort of thing.
If anyone that follows the popular TV show, Better Call Saul, you would see that,
I've not seen that show.
Basically about a very sharky lawyer. I, for one, can assure you that 99.9% of lawyers are complete opposites.
The reason why it makes...
And in fact, you get in trouble for anything to do with half the stuff that goes on.
And this is what we're talking about today. So, in fact, the reason why television is so interesting is because it is... art imitating art. It is not life imitating art. It's not art imitating life. It is literally fake. Most of it is all fake.
Most of it, though. But these are the situations where I've got
some really fun ones here, and there is my personal favourite in there as well. Yes. So it's an old case, but the rest of them are all very new in the last couple of years. So I'm just going to kick it off.
Go for it.
And so this one is a barrister or solicitor in New South Wales harassed a junior solicitor, had found that there was unsatisfactory conduct. Now this is about Mr. Raphael and Ms. X, and this is back in June 2017. Now the language is that she was sitting in a conference room alone with the door closed while she obtained information from her supervising solicitor.
Sure.
So this is a young girl in a room alone with an older solicitor.
Yeah.
Now the respondent entered the room and after referring to Ms. X's wedding ring, said words to the effect, "Won't your husband get jealous because we're spending so much time together? He'll think something's going on."
She's understandably
a little bit edgy. Now... And it says here, during the conversation, Ms. X became visibly upset and began to cry. And the respondent placed his arms on her shoulder for between 10 to 20 seconds, kissed her on top of her head and said, "Don't worry, you poor thing."
So the employment lawyers out there are all screaming out for...
So they did talk about sexual harassment, and at the time that she was a junior solicitor and he was 78 years old.
Yes.
So there were lots and lots of issues on this one, which I thought, you can delve into it, and behaviour constituted unsatisfactory professional conduct, and whether the orders were appropriate. Now, with respect to the first issue. So there were two issues, whether it was unsatisfactory conduct and whether the orders were appropriate.
Yes.
With respect to the first issue, the tribunal found that in the definition of sexual harassment and the barrister rules, that they considered those two. And the barrister rules on this particular point, I have them here. Barrister Rule 125 defines workplace bullying as unreasonable behaviour that could reasonably be expected to intimidate, degrade, humiliate, isolate, alienate or cause serious offence to a person in a workplace.
It's ticking a few boxes.
Well, I think so.
It's ticking off.
Well, the tribunal felt so. So the tribunal concluded that by putting his arm around her and kissing her on the head, that he engaged in conduct that constituted sexual harassment. And they found that unsolicited act of physical intimacy together with the respondent's comment, "Won't your husband be jealous?"
Created a sexual element to it.
That's right. Regardless of the respondent's intentions, his actions objectively had sexual undertones and involved an overt act of sexual intimacy. Yeah. Because he wouldn't be kissing some dude on the head.
No.
Anyways.
No. It's,
crazy.
I think that's a fairly clear case of sexual harassment. But one of the interesting things about this is that this is
not about sexual harassment.
Yes. It's not a case about...
Yeah, and we'll remind
you... It's not like she's suing him for compensation due to the...
No, so we'll keep reminding you, the viewers and the listeners of this, because we're talking about when solicitors get into trouble for being badly behaved as the role of a solicitor.
Yeah.
This is about, Legal Services Commission conduct stuff. So there was all this, and then it says, regardless of the respondent's intentions, his actions were objectively sexual. The tribunal noted there was a vast power imbalance, and she was an inexperienced solicitor. He was extremely experienced, and a reasonable person having regard to all the circumstances would have anticipated that she would have been offended, humiliated and intimidated. And they talk about workplace bullying under section 125 of the Barrister Rules, which goes to that. Goes to that one we just mentioned. And it says, and just going to the solicitor part of this, it says, moreover, the respondent's conduct, while not dishonest, was otherwise discreditable to a barrister and likely to diminish public confidence in the legal profession or administration of justice. And
therein lies the
problem.
The problem where it's essentially showing that he's basically no longer fit and proper.
That's right.
Because fit and proper has a few different elements, one being the way in which an action may be perceived by the public. And you can certainly see the public is not going to take too kindly to a profession that seeks to not necessarily protect, but in many ways condone sexual harassment.
By silence or by whatever.
And it's not something that I think is becoming of a solicitor, and especially a senior one.
Well, this is really interesting because, of course, both parties get a chance to have their say here. So, Legal Service Commission being the applicant's kind of proponent here, and then they've got the defendant themselves, the respondent on this. And the tribunal accepted that the respondent's evidence, and supported by several referees, so he dragged a pile of people into this, who knew him well, that he did not intend to distress, upset, humiliate or embarrass her. Now, and the tribunal didn't accept that. Because why would they?
An objective test.
Yeah, it's like, dude. It says, however, in the light of extensive media coverage about sexual harassment in the legal profession, and having been spoken to by colleagues about similar remarks he's made in the past, the tribunal noticed that the respondent's initial complete lack of understanding of the nature and potential effect of the behaviour was of considerable concern.
And that's a fair enough comment. I mean, if it's been going on for some time, it seems like there might be some similar... maybe not so serious circumstances in the past.
This is all about fit and proper. What does somebody feel like this is going to be acceptable behaviour in the workplace? And it's really interesting because we get some insight into some of the defence here, because the tribunal further stated that the respondent needs to understand that this kind of conduct is not perceived by the vast majority of women to be comforting, chivalrous or even vaguely humorous.
Exactly. I mean...
So it's an interesting insight into why they made the decision that they made. In terms of, can't remember whether this guy was struck off in the end, but, they disciplined him for essentially behaving like a douche.
Exactly. I mean, when we're thinking about these disciplinary issues, we're thinking about what is and isn't a fit and proper person, and basically who should be and who should not be in the profession.
That's right.
And although this may not necessarily be the way it's done, I certainly see it as a starting point, as both as a general public, being the upholders of the rule of law and etc., and as a profession ourselves, is to look at what we want our lawyers to be.
That's right.
What does the public want the lawyers to be, and what do the lawyers themselves want each other to be? And I think as a starting point, that's a really good place to go, because when you think about his actions, I don't think the public necessarily wants its lawyers to, one, be committing what in different under different sections,
in a different environment.
In a different environment may have conceived to be criminal.
Yeah, criminal or sexual harassment under the Act.
Yeah, and neither do the lawyers. I mean, we know that over 50% of lawyers are female.
That's right.
I think it's abundantly clear that would not be perceived to be something that is very comfortable or welcomed by at least, if not more.
Well, the tribunal feels the same way. This is a really interesting segue, because what we're talking about here is what the public perceive us to be, and this administration of justice and the confidence that public have in their lawyers and the administration of justice. And in many ways that undertones everything that we're going to be talking about today. But this is a really interesting one. This is a former solicitor was refused anonymity in a professional misconduct proceedings. And in this case, this woman, Michelle Cherie Harrington, had engaged in professional misconduct in relation to 5 occasions over several years. Right. So that was found.
Right, that's quite...
It's quite big, and His Honour noted that some of Ms Harrington's professional misconduct related to the management of trust account in her firm.
Right.
Harrington Legal. So, okay, we'll keep moving forward here. One charges alleges failure of competence and diligence with respect to the management of the firm's trust account. Now, so we're talking about a solicitor who's already been disciplined, and she is seeking to have her name kind of hidden from the public.
Yeah.
And when we're talking about this, they cancelled her practicing certificate back in March 2019.
Right. So she's now wanting to come back? Or?
No. This is about keeping her name out of the documents.
Right.
Ms. X, as such.
Right. A confidentiality.
Yeah. Confidentiality. And His Honour said that Ms Harrington has asked for the tribunal to make an order to suppress the publication of her name. Publication of her matter. Ms Harrington asked the tribunal to make a non-publication order. He said the only basis for making the request is a concern that Ms Harrington's past health issues may have an impact on her present employment if published publicly. And he goes on to say that concern is not, however, sufficient to warrant a non-publication order, and in any event, there is a clear public interest in the circumstances of Ms Harrington's contraventions and the orders of her made to be publicly available. So really what they've said is...
Well, I mean, this is going back to open justice in the end.
It does. And we ask our policemen or police officers, I should say policemen, it's terrible, isn't it? But we ask our police officers to hold themselves to a higher standard. And in fact, they do get penalised, sometimes quite severely, for not doing that. And I think people fail to see that happens to us too.
All the time. And it, as I said, it comes back to actually a very old maxim in many ways about open justice, which is it's in the public's interest to know what goes on in the society, and if there is disciplinary matters which are happening which may have an effect on someone down the track, then they ought to know about
the effective administration.
Back in the oldie times, this would have been, literally a public court with,
That's right.
People witnessing and actually
everyone standing there watching it all happen.
But the same thing kind of applies, and I mean now with Google, a simple Google search would have brought that person's name up, and a future employer or someone who may have some concerns around what she did in the past ought to know about it.
Well, yes, in fact, I mean, it probably permeates through, most of the things that she does now. Bad decisions from lawyers create bad futures for lawyers sometimes.
And it goes to one of the key outcomes when it comes to any type of disciplinary matter, whether it be criminal, whether it be professional, whether it be anything for that matter, about deterrence, and deterrence only happens if people know about it.
Yeah, it's it. It's not a crime unless you get caught, type of thing. Absolutely. So I think that the next two are going to be, I think, some of your favourites. So this is a QCAT strikes off solicitor for practising without a practising certificate.
Right. This is one that comes up. I don't think too many people find themselves in before the LSC because of it, but it certainly gets warned an awful lot.
This is a really interesting one because what people don't know about practising certificates is there is a hierarchy of practising certificates. Yes. Just because your little brother became a solicitor 2 weeks ago does not mean they can help you today with their legal problem.
Even worse, if they haven't even got admitted.
They're a law student they're between that little period.
Even worse if they haven't even finished their law degree.
Well, this one was struck off. And the specific charge, there were a number of them. I just love these cases because they're so wild. So the respondent engaged in legal practice without holding a practising certificate. He applied for a practising certificate which had not been issued due to the respondent's failure to make payment. Okay, that's interesting. He engaged in legal practice, sending correspondence including offer to settle on letterhead with a signature block which represented that he was a principal of Martin Doyle Law. So
a principal?
Well, yeah, right. Principal solicitor. And charge 2, the respondent represented or advertised an entitlement to engage in legal practice when he wasn't, on his website when he wasn't entitled to. Number 3, the respondent purported to act for a party and dishonestly represented to another party that the court date had been set when no application had been filed and no hearing date.
Right, so...
What? You're
just
making stuff
lying.
up. You're just making stuff up.
Lying in order to achieve an outcome.
Number 4, failed to maintain reasonable standards of competence and diligence by wrongly stating in a letter that it was a general requirement under law for an executor to reside in Queensland when there was no such requirement.
Right.
Representing in a meeting that the respondent was going to bring applications which were not legally available in the circumstances, and representing in the same meeting that he'd spent around 20 grand of costs already, which was false. He's just making shit up, bro.
So he's lying.
Yeah, just...
And...
But to what purpose? I mean, where's his end game here? To get his client the best result possible? Is that where he was going with this?
I imagine it probably is, and we've actually spoken about this on the podcast before, that one of the reasons a lot of people get into, well, not a lot of the reasons for people getting into trouble as solicitors when it comes to dishonesty, and they are extremely harsh on it, and one of the reasons being is we need to be able to trust each other, or else...
That's right.
Smoke and mirrors will only seek to harm the public, because negotiations are going to get very difficult. I mean, it seems to me that although I haven't read the case, it seems he's probably saying it in the scheme of
negotiating.
Or putting a client in a position to make the other side feel exposed such that they might settle. But if everyone is lying, then everything anyone says is meaningless.
Well, that's right.
Because you can't possibly know if it's a lie or not.
And you can't buy into any of it. I mean, it's not a case of honesty is the best policy. It's a case of honesty is the only policy.
And actually, that case seems to also show that in many ways, competency is a simple threshold.
Yes.
It's not a range of competency required. It is you need to be competent or not, and you will need to be correct. Absolute.
Well, I think this goes further as well, because people think solicitors are all about, big teeth, and you get far more.
Send very threatening things.
Yeah, very threatening. And this is what the commission had to say about some of the conduct. The respondent in his submissions characterised the conduct as assisting a friend in legal trouble over a 6 to 8 week period, which he didn't have a practising certificate. The tribunal considered, however, his conduct not involved only practising without a certificate, but dishonesty, misleading statements, unethical dealings, and actions that displayed incompetence and unacceptable threats to a layperson. They said, had Mr. Doyle behaved in a courteous, honest and competent way in that 6 to 8 period when assisting a friend, particularly given the long delay in prosecution of these charges and its impact on him, then there would have been some considerable force in his submissions that he had learned his lesson, and an adequate response to the charges would have been a reprimand. But that is not the situation.
So not only was he
unlawfully, because he was practicing certificate.
Not only was he not truly a lawyer in the way we would conceive it to be, but he hasn't even acted in a way which was becoming of one.
That's right.
Because he's not even upholding the basic ethical standards.
We do come across, I think, hard to say whether it's becoming more and more prevalent, but I think we're getting better at it personally, is we come across every now and again a lawyer who seems to feel that being obstructive at every single turn is the right move to make. And it really isn't.
No, it doesn't work.
I just do not feel that being obstructive, angry, just always saying no, being the opposition is always the way to move something forward. And in this case, I think he fell foul of this. And it says, while the tribunal acknowledged the respondent's 10 years of blameless practice, it ultimately determines that that the only order which would sufficiently protect the public and the retribution and the reputation of the legal profession was to recommend that it be removed from the role. So again, it goes to what the public are going to be seen as.
And isn't it interesting that they've also added another level of intricacy to what our ethics need to be, which is when you're dealing with a layperson. Something that many people may not be aware of is when you're dealing, as lawyers, dealing with lay people or just non-lawyers in this case, you do have to take a different approach, don't you?
No, you really do, because we understand things with a certain set of lenses, and we tell our clients how to understand that set of lens.
Yeah.
I mean, that's part of our job. But when we're dealing with the other side, they don't have that lens to look through, and we've got to be really careful that we're not being overbearing and forcing someone to a position because they just don't understand where it is, because of this persona that lawyers are liars, that we're always trying to pull the wool over somebody's eyes. We have to make sure that the other side, who aren't legally represented, understand the full scope of what's happening.
And there's a certain unfair advantage which that can create, especially if someone is being untruthful, as that guy was being, which was, for example, he's telling a lay person that a court date is to come and it's been set down. A lawyer, any kind of competent lawyer certainly, will cross-check that.
That's right.
And we have, for example, an account which allows us to access court dates. We are well aware of how to look that up ourselves, such that lack of truthfulness from him is very much mitigated.
That's right.
But for someone who's, I can't imagine that layperson would have any clue that portal even exists.
Or
frankly.
that there are applications that are able to be brought which are not real.
Yeah,
you can't bring it. This happens from
Oh.
time to time when I speak to people on my free telephone consults. They say to me things like, they're going to say they're going to be seeking costs. I'm like, how? It's a no-cost jurisdiction. They're going to put a counterclaim in. This is not a jurisdiction that one can do that. It's you hear this stuff all the time, this kind of language that gets thrown about. And that's okay if it gets thrown about by two lay people just chucking mud at each other. But when there's a solicitor doing that, people believe it.
Yes.
It becomes scary.
Yeah. And it can also put us at conflict with our own clients.
Yes.
Especially if they are the ones who are paying for a lawyer and the other side is choosing not to. They can very much see it as a situation where their lawyers, the ones that they're paying for, are having to be essentially assisting the other side in circumstances when they're in conflict.
It's really interesting. And anyway, this person was struck off for getting up to that sort of mischief. Didn't matter, he had 10 years of good practice behind him. That was the end of it. Interesting. I think there's another one you're going to like. Bogus Gold Coast solicitor banned from running their practice. I think this is one of your favourites.
I have heard and read about this one, if it's the one I'm thinking about. Martin Burns' decision comes for more than 2.5 years after the Queensland Society won a Supreme Court injunction restraining Moore, who was operating a Madriba law firm, Stenton and Moore, from engaging in legal practice or holding herself up as a qualified practitioner. So I'm just going to read a little bit about this because this case is fascinating. The court was told Moore first appeared as a so-called solicitor when the independent law practice Stretton and Moore sprung up in Madriba in January 2014. In his 11-page decision, Justice Burns said, to the extent that this name was intended to convey the impression that two persons, named Stretton and Moore, were qualified providers of legal services, to say in the least was misleading. Graham Stretton was legally qualified. Ms. Moore was not. And she wasn't able to run a practice anywhere else. And then, lack of any legal credentials, Moore commenced work in the practice from the inception, holding herself out to be the executive officer, and remained there after Mr. Stretton left. So you've got a situation where Stretton and Moore, there's no legally trained people running
anyone
or
at all.
Involved.
There's no lawyers there at all.
No.
There's only one person and she's not a lawyer.
Right.
The LSE submitted that Moore made two deceitful attempts to install, I love this, to install someone as the legal practitioner director of the company in a bid to keep the necessary statutory appearances.
So not for a lawyer to actually do the work, but to just simply have them on the books in order
That's
to...
right. Both attempts failed, including one appointment with a reputable practitioner without his knowledge or consent.
So
What?
She forged someone's...
I assume so. Just pretended that he was coming on
passing off as them.
board, I
Geez,
guess.
that alone, I think, will get you struck off.
Apparently 42 clients of Stratton and Moore made claims against the Queensland Law Society's Fidelity Fund Guarantee Fund, resulting in compensation payments of $570,000. There was a $430,000 deficiency in the trust fund.
So just for everyone out there, what are we talking about when we're thinking about claims from clients in relation to trust funds?
Yeah, so this is all about them going, I've paid, where is it?
And the money's no longer there.
It's no longer there.
It's no longer there. So these people have paid upfront for legal work, and she's, from my understanding, essentially run off with the money, spent it.
She's gone.
Moved it.
And in fact, it says the serious nature, real likelihood that she might engage in similar nature means that she can't do this anymore. Moore did not participate in proceedings against her and failed to appear at the hearing.
I'm not surprised.
I'm not surprised either.
I'm not surprised.
I'm not surprised
because
either.
The two issues there are, there's really three, isn't there? There is the fact that she performed legal work when she is not a lawyer. And then I'm not sure what
it's all
the
this
word...
passing off shit.
Yeah, I'm not sure what the word is, but stealing someone's identity
the whole
and
thing
claiming that they are part of your...
It's just a wild...
In order to do so, you'd have to be incredibly dishonest. You would have to find out, or either fake their signature, write documents which are proposed to come from that person.
It just goes off the kazam. So
and then to just actually steal money.
She started a law firm that pretended to have two people in it. There was only one, and then there was nobody, and she was just running as if she... What was the end game here? And then she just disappeared. With the money, I guess. $500,000, thanks.
And she...
$500,000.
I'm not sure about the others that we've been mentioning, but certainly I remember getting an email from the Queensland Law Society because she got put on a do not hire list.
And in fact, we've talked about this list.
Yes, it's a blacklist.
It's a blacklist.
I can't imagine it's too long, but...
Have you ever looked at it?
I have not.
There's about 30 names on it the last time I looked.
So there's 30 people that, if you are a law firm...
You just can't.
You should be...
What surprises me about that list is how many people who have pseudonames.
Go on.
Yeah, well, they'll be, Stephanie Rice, and then it'll be Stephanie Ripe, and then and then it'll be Steph Rice, or and it's all these.
Once a crook, always a crook.
Wow, unbelievable. So I have another one here. I've got several of them. But I've got a few more, but this one is really fun. I actually feel sorry for this poor sod. So the respondent was
different.
Yeah, I do.
Usually they have no sympathy. From the rest of us, no sympathy.
Well, I kind of do, because I understand how hard it is to get it right in a law firm, and how any mistake is punishable by death.
Yeah.
This solicitor was struck off, by the way. So the respondent was admitted to as a legal practitioner in 2014, and he was employed by Wayne Wong and Associates from 2014 to 2017. So probably about 2 years.
Yep.
Now, there was a couple of things that he did. Okay, so episodes 1 and 2. The first episode involved the respondent misleading the vendor's solicitor in his failure to lodge a liquor license in the time, and then made false representations to this vendor solicitor that the liquor license had been approved in order to secure a settlement. Then he went to great lengths to fraudulently create a fake liquor license.
So
what?
He's, for whatever reason, forgotten to do something.
He's forgotten to file it. It's been rejected.
He's in trouble now from his client.
And now he needs to produce one.
He's trying to fix a problem and keep his reputation with his client.
But wait, there's more. Instead of stopping there, he did not stop there. Notwithstanding all of this, he took carriage of a matter and required him to make a claim for compensation on behalf of a client of $180,000. The matter was under the supervision of Mr. Wong. However, the respondent failed to file the required documentation and lied to the client about the progress of the claim.
Right. So a similar problem.
Here we go again. Yeah.
Here we go again.
Following the client's queries, the claim's progress, the respondent withdrew a cheque from his own personal account for $15,000 and then $165,000 from the trust account, forging his boss's signature.
So in order to make the client feel as though they've won,
he took the money from his own account.
The client's just going to see some $185,000.
He's emptied his own account and he's also emptied the trust account of $165,000, forging his boss's signature.
Yep.
Okay. The respondent fraudulently purported to be the client, created a false email account and dishonestly corresponded with Mr. Wong, advising that the bank cheque had been returned. What? So once Mr. Wong, the reason was because once Mr. Wong found out all about this, he asked the respondent to contact the client and get him to return the funds. So instead of doing that, he created a fake email account and pretended
so the client still thinks they've won.
Still thinks he's won.
Because they haven't even been asked to give the money back.
Okay, so for obvious reasons, as a result of his wrongdoings, the practitioner was charged with theft and obtaining a financial advantage by deception and was convicted on both accounts. So the reason why I feel sorry for him, I mean, he was disbarred because of the conduct.
There's simply no ways that.
But you've got to worry. I mean, when we were, I mean, you're still relatively new, but you've moved past the junior solicitor range. When you're young in law, every mistake you make is so critical because you feel like
you don't know any different.
You don't know any different, and you feel like the next mistake is the one that gets you fired.
Yeah.
And you always feel that in law because we have to be so perfect all the time. And this poor chap probably felt like that.
Yeah.
He just made the wrong decisions. Goes back to the fit and proper problem.
And his fundamental failing here is probably one which is related to his ego, and the inability to deal with the stress involved with the job.
And you're absolutely right.
Because those circumstances which would have led to it, which just having not read the case, but I can
you can see it flow out.
I can see it happening. He's at a situation where the two clients involved may be valuable of some description.
Yeah.
And
his boss is particularly fiery.
And he's struggling to keep up with the work, whether that be the quality or the difficulty of the work itself or the quantity. And he's made mistakes which, I mean, many solicitors have made in the past, albeit those were quite on the bigger side, certainly.
I love the fraud aspects of this. Just making shit up.
Oh, no, I was saying about the fact that he didn't file the various things on time.
It's just, yeah.
But the problem he had, I think, was that he wasn't open about the mistakes.
No, and in fact...
And instead of putting his hand up and admitting his fault, knowing full well that might lead to being fired, chose to act dishonestly. And that's, in there lies the problem, and you can see why they might have struck him off, because that might happen again. And it probably will.
And it says an unusual feature of the case was that no personal benefit was gained, unlike the lady who stole $500,000. Rather, it was appeared that his dishonest actions were driven by a desire to avoid embarrassment for his mistakes, due to his lack of insight into his misconduct and failure to take steps to rehabilitate. They had no choice but to remove him.
Because the circumstances, the ingredients of that little disaster is going to happen again and again and again. Yeah. And he's obviously doesn't have something in his persona that is able to...
Just not fit and proper.
He's not genuinely fit and proper.
As lawyers...
For different reasons.
Lawyers make mistakes, just like everybody else does. But our mistakes can be quite devastating for somebody else. It's not just devastating for us as lawyers, which can be, because some mistakes we make can be career-ending. But needless to say, no matter what mistake we make, whether it's career-ending or not, one has to admit to it. And we have to have the fortitude of, character to be able to go, you know what, that was a mistake, I made it, it's the end of my career, but I'll cop it.
The ability to put the interests of someone else, because as lawyers your clients are putting very much their interest in your hand, And it's the ability to basically put their interest above your own.
That's right.
Because if he had put his hands up and hopefully he would have just never done the wrong thing in the first place. But
if he had once made the application,
once he had made the mistakes, he ought to have put his hand up, said that he'd done the wrong thing, and there was a good chance he probably would have been fined, and that may have been legitimate.
But he gets to practice another day. That's right. Yeah. And he may have been disciplined for missing the date from the LSC point of view, but
it would not have been the same.
No, admit fast. Have that
transparency, open
character. This is one that came up really recently in August this year. So this month, this is about postbox lawyers.
Oh, so what are we talking about when you say?
Yeah, because this came up, and I said to you, "What is a postbox lawyer? What's going on here?"
I've heard a similar term, but when they're saying postbox, what do they mean?
Yeah, so what they mean essentially is the lawyer is the middle person, and the person here is making all the decisions, filtering it through the lawyer and giving it to the client. Yes. The trouble is, we are meant to be the ones advising the client independently.
We are not postal services.
We're not a postal service, and we have this from time to time with our own clients, where they just say, you know what, I want you to write this, and I want you to send it. And
on your letterhead.
On your letterhead. And that's getting close to being a postal solicitor, because what we have to do is take our skill and expertise, advise our client accordingly, and do the best thing for our client. Yes, we must act. We must act on client instructions, but if our client is not listening to us, then we're just a wrong fit.
Yeah, and it goes to your duties, your 3 duties. And it's important to remember that the first one is to the court. And if the client is asking us to simply say whatever they want whatever they want us to say, knowing full well that might be detrimental to the proceeds of justice or whatever that might be, then we're not doing our duty.
No, we're not. And this was all about a litigation funder, the solicitor who was doing the class action, and the peeps on the other side of this, the clients. And what was happening was this litigation funder was basically calling the shots and making it and doing it in their own interests. Because of course it's a litigation. They're a business,
and that's fine.
Every right to do that, but the solicitor should be acting as that middle person, to be acting in the best interest of the client, to say no. And this was a problem. Mr. Zeta's lack of self-motivation to identify his failings and the inability to fully accept the significance of his conduct was noted in the justification of striking him from the role. In a reflection of his views towards the appropriate ethical conduct during the time highlighted, he was not capable of discharging his responsibilities in the administration of justice. So again, we're talking about how our administration of justice is. Mr. Zeta accepted that he should not have agreed to take on the case initially, given his inexperience with class actions, and accordingly he acknowledged that he would not have been involved in complex commercial litigation such as this one in the future. While he contended that he was manipulated, he had since suffered great detriment to his public and personal life, and the court noted again that his personal circumstances would not be taken into account.
Isn't that interesting that they've highlighted the fact that he picked and chose the wrong case? Something that we're certainly cognizant of.
We as solicitors are asked by the community to provide competent legal advice. It's really a bottom line issue, right? Yes, there's nothing wrong with general practitioners out there touching everything and having a bit of an idea and doing things. But how deep do you go?
Yeah.
We have clients that ask us about the odd commercial thing. Oh, do I need to pay super on that? I'm not a tax lawyer, but I can repeat what the ATO says, and says if it's ordinary earnings, then yes. What is ordinary earnings is not a matter for me to make a decision on. But if I delve into that tax and tell them what an ordinary earning is, and they hear that, act on it, then why aren't I responsible for that?
Because the clients didn't have any reason to believe otherwise.
Not to believe me.
And we certainly advocate for it being to stay in your lane, and to make sure that you're only really doing what you feel comfortable, because when you don't do that is when you find yourself, one, it's generally quite unprofitable, but two, you end up doing things such as just relying on your funder to give you whatever, to tell you what to do next.
Yeah.
And I can certainly see where he went into problems there. I mean, here in MJT, we're a small team. I don't think we could do a class action.
Hell no.
We wouldn't have the resources for it, and we wouldn't be able to provide that competent legal advice.
And I intellectually know that there are special rules about class actions that I don't actually know how they work in practice.
Yeah.
And I'm not a stupid person. I can sit there and learn it, but actually this job is better to someone who knows how to do that better.
Yeah. And going back to one of the other cases, it is putting the interests of the client before your own.
That's right.
Because I'm sure that class action would be really profitable.
That's right, for the firm itself.
For the firm and for anyone involved.
Yeah.
But it's not in the client's interests.
Is it Trilby Misso that was born from that one?
Could be. I know they do some.
What is it? Eric Brockovich or whatever?
I think that's Shine.
Shine Lawyers, which just kind of grew up from a single, because they had the money all of a sudden. It's very. I mean, the whole concept is very interesting, but you can't do it if you're not great at that.
You need to stay in your lane.
You need to stay in your lane. Now, this one, solicitor acts for friends.
Yes, the classic.
Right.
The classic. I've got a legal question. What should I do at the barbecue?
That's right. That's right.
The correct answer to that is
I have no idea, dude.
I don't do that at all.
This guy's a sole practitioner, so had the right practicing certificate, but in the area of migration.
Huh?
And he received. This is the interesting thing. Mr. Indros received $7,000 in advance from his clients for services when he held a practicing certificate that did not authorise receipt of trust monies.
So what are we talking about there?
And he put the funds into his personal bank account.
So he's not allowed to have a trust account?
For everyone out there, I have to seek permission from the Law Society to handle trust monies, and there's a bunch of things I have to do to show the Law Society that I know what I'm doing. Okay. And one of them is create a new bank account. So the general funds and the trust funds are not intermingled.
Yeah.
And this is exactly what he did. He wasn't authorised to receipt trust money, so he didn't get that permission from the Law Society. And he placed trust monies into his own personal account. He was aware that this was a breach, claimed that his relationship with the client went beyond normal client-lawyer relationship due to their long-standing connection. Really? Mm. Obviously, the Commission didn't buy it. The Tribunal rejected this reasoning, emphasised that trust monies were sacred and the proper handling of such monies was fundamental obligation of a solicitor. The Tribunal noted that acting for friends cannot be justified as an excuse to depart from the usual practices.
Yes, because
bring it back to basics.
Where does that end? I mean,
it's a well that has no bottom, dude.
Well, and I mean, just because you're your friend doesn't mean you have to treat them any differently. I mean, you should be treating everyone as though it's the highest volume of care.
But he went further than this. So he was demonstrating what was required in a visa application by showing somebody else's CV. But they didn't redact. The entire CV was there to see. And that was a breach of confidentiality. And the Victorian Legal Services Commission submitted that it would have taken little effort to redact sensitive information from the documents. But the Tribunal was still not satisfied that it would have been appropriate to present it anyway, of course. Clients expect their personal information that they provide to the lawyers to be treated with complete confidentiality.
Yeah. And this comes to one of the very first things we were speaking about, which is what the public perceives about us, because that governs how we go about our legal practice. And we still have problems about this almost every day, where clients aren't comfortable giving us information which we need in order to provide the right legal advice, for fear of this. And we certainly reiterate that we do keep things.
We keep everyone's secrets. I've kept secrets for a decade. You keep everyone's secrets. No, that's what we do.
There really is no scuttlebutt that happens.
There is no scuttlebutt. There is no wiggle room. It is secret.
It is secret because if it wasn't, then no one would be giving us any information, and we wouldn't be able to do our jobs, frankly.
Nope. So he goes further. What he starts doing is falsifying government information, emails from government, because he was getting lots of pressure from his family members to get updates, and he failed to respond to statutory information requests from those organisations, and they just said a frequent argument raised by the practitioner was that he felt pressured to act for the clients due to their personal relations, and that his mistake was not being able to say no. While the tribunal recognised the practitioner's intention to never enrich himself, it was emphasised that lawyers must nevertheless be professional and put their professional obligations first, regardless of the personal connection.
In their lies.
Again.
The couldn't have summed it up any better about the problems of acting for friends. When you have to say no, you have to be tough love often.
Oh, tough love, yes.
And
yeah.
You know, for long-term listeners, before I was in employment law, I was in family law. And certainly where I used to work and absolutely live by this was to not do any work for friends and family.
Oh.
One of the other kind of interesting issues that we used to arise was you might not want to know. Because one, you need your clients to be absolutely forthcoming and on one hand, they're probably not going to tell you everything you need to know because they want to preserve their own relationship with you. But even if they do, you might not want to know about it.
No.
You might, because you're gonna learn everything at that point, and you might find yourself without a friend after it, and it's going to kind of compromise you as well.
Yeah. So this is another one, 9-year ban. So I'm just going to do this one as an overview, but they basically caused detriment and distress and confusion and frustration to clients, was dishonourable, blatantly dishonest and deceitful, engaged in conflict that caused financial loss or disadvantage to our clients, grossly overcharged clients and dishonestly inflated invoices, mishandled trust monies, disobeyed lawful instructions and directions from the board of the appointed managers, so when it was finally found out there was somebody else looking over them, and failed to meet reasonable standards of competence and diligence. This is like,
Greed.
9 years later, dude. 9 years he's lost his practicing certificate for.
Greed has come over that person, I believe.
Yep. He says rather than ask for help or refer clients to another firm, which he actively avoided, he continued to juggle files and damage the legal and financial interests of the clients.
So took overinflated how much he was paying, how much he was charging, taking all the work he possibly could, even the ones that he knew that he shouldn't.
That's right.
Just essentially
to make money. Yeah.
And failing to stand their way.
Yep. I've got 2 last ones.
Yes.
These are really juicy. I've left the good ones to last. The first one is the Ipswich solicitor of Paul Pistali.
Yes,
And of those who are uninitiated, you can Google Paul Pistali, but I think he was found at the airport with a suitcase full of money, right?
Yes, he's currently in prison for corruption.
Yeah.
Basically, if you were to put it as...
And I'm not sure whether his lawyer is still in prison, but he was certainly sentenced to 18 months jail. Right, so, and this is for extortion.
So when we're thinking about extortion, we're thinking about threatening something in order to create a financial
Exactly.
gain.
So the tribunal, this is all about the conduct from the solicitor's point of view. Yep. And we'll just go back to what we originally said. Yes, there's lots of criminal action here, but what we're talking about is a fit and proper. Yep. Is the conduct suitable for a solicitor? The tribunal, headed by the judicial manager, His Honourable Duncan Meakin, it was left with no alternative but to strike off Mackenzie to protect the public and the reputation of the legal profession. So once again, we go back. Mackenzie was sentenced to 18 months jail after the district court found him guilty of 1 count of extortion, and his sentence was suspended after serving 9 months in custody. Okay.
So he spent 9 months jail. He
was convicted of extortion for sending a letter of demand without reasonable cause at the request of Pistali. Apparently, during 2nd November 2020 hearing, Mackenzie challenged an application by the Queensland Law Society, arguing he is now a changed man.
Right, so he's realised the error in his ways, and now he's suddenly turned a corner, has he?
Yeah, and he says there's no alternative available that will sufficiently protect the public and the reputation of the profession, other than to recommend his name be removed from the role.
Right, so
again,
it's greed, I imagine.
Yeah,
greed is his problem.
He got up to all sorts of mischief, as you can imagine, and he did it on the
on the whim of someone else who was doing the wrong thing.
That's right.
And I mean, I don't know too much about him, but I imagine he's fairly senior in nature, and it's fairly difficult to argue that someone who's so senior could change the spots so fast.
Well, I think, there's probably a lot reading between the lines here we don't know about. We haven't, sat there during the criminal trial and found out what all the other mischief that could have been up to that didn't get in front of the commission because it wasn't quite that sort of thing. But we're not allowed to try to extort on behalf of our clients. And there's a fine line there, I think, when we write letters saying, look, our client has this action that's available to him, but he's willing to make concessions in order to give up those rights. That's one thing. But just plainly saying that this is what's happening when it's not, and I want money from you when the thing that's you're claiming is happening isn't, is extortion.
Yeah. It's when certainly when there is no actual legal recourse that you are threatening or proposing to proceed with.
Yeah.
And that kind of also goes to the issue about dealing with lay people.
Yes.
Which is they might just simply believe you and give $10,000.
And these two
in circumstances where there was no.
Yeah, and in this situation, they were lay people who they were talking to, so they got. There was this whole problem with it.
Because where does that end? I mean, if we allowed that, then lawyers could just start essentially BSing and just send letter demands to everyone. Talk about acts that don't even exist.
And hope that something sinks and we get the money we want. Woo!
1% works?
Yeah,
1%
that's all you need. I mean, essentially we would be the Nigerian scam artists.
Essentially, yes.
The phone call where you get, look out, this is the ATO, look out, the police are at your door, that type of...
It's essentially the exact same thing, just different.
A bit more finesse.
Yes.
So this one is my all-time favourite case. This is about Robin Tampoi.
Yes.
This is Chappelle Corby's lawyer here in Australia.
Yes.
I love this case. This case actually came up when I was getting to the sort of... I was still studying, and this was a very fascinating case. So I'm going to read out. I've actually got the case itself, and I'm going to read out some of the more interesting parts. Now, Ms. Corby had been charged in Indonesia in October 2004 with a number of serious criminal offences arising from allegations of drug smuggling. Now, I just want to remind everybody, this is not about this case is not about Chappelle Corby. No. This case is about the solicitor and his behaviour.
Yes, in defending her.
In February 2005, Ron Baker retained Houlihan lawyers to assist in Ms. Corby's Indonesian lawyers in representing her. The client agreement set out the work to be undertaken as part of the retainer. Now, I'm going to read it, but it's very broad. The firm will undertake all steps necessary to assist the Indonesian legal team currently representing Chappelle Corby against drug charges in Indonesia, which shall include, but not be limited to, investigating the claim, gathering evidence, providing advice in respect to the claim, attending all procedures necessary for the disclosure of the Australian and other bodies of information relevant to the defence, including attending at conferences, representing at those bodies, appearing before the media, so on and so forth. So this you can see where this is going. So that's the scope. In a television interview published on the 26th of June 2005 on the Channel 9 programme Sunday, Mr. Tampoi disclosed the content of a conversation he had in Indonesia with the client, and further commented on the confidential information by saying that Mercedes Corby had lied to him. And in disclosing and commenting on confidential information, the respondent breached his duty of confidentiality to his client, Ms. Chappelle Corby.
Yeah. So it's a private conversation, ought to be kept that way.
That's right. And he was arguing at the time that this information was in the public already, so not confidential. And in fact, but in any event, he wasn't a client of Mercedes wasn't a client of his.
No, but certainly Chappelle's case is something that is confidential.
Yeah, he says, in my view, this represents professional misconduct. It is fundamental to the relationship between the solicitor and client that the legal practitioner will not reveal confidential information. And it's hard to think of a more egregious breach to do than to do it on national television.
It's not about the recipient or the conversation for who you're having the conversation with. It's about what you're speaking about.
Yep, that's right. So he was disclosing confidential information and he did it on national television. And that's in perpetuity. You just look it up. I mean, you can watch it. Unbelievable. What was he thinking?
It's repeating on time and time again. I mean, you're just recording.
What was he thinking? The second charge is an allegation of unsatisfactory professional conduct. That is, in the course of Mr. Tampo's participation in the documentary Chappelle Corby, The Hidden Truth, he made statements which were scandalous, offensive, and or likely to bring the profession into disrepute.
What did he say that was so...
Particulars of charge 2. Mr. Tampo willingly participated in a documentary. The documentary was on broadcast in Australia between the 22nd and 24th of June. Documented by giving interviews, making comments and allowing himself to be recorded. In the course of his participation in the documentary, Mr. Tampo made the following statements and or comments which are scandalous, offensive, like to bring. Referring to Ms. Corby's family, he said, "These are the biggest pile of trash I have ever come across in my life. I've never seen a more ungrateful, nasty piece of work than this woman and this family." He also absorbed, "I am watching Rosalie, whatever her fucking name is, Corby, on TV last night, because now she thinks she's a fucking rock star, superstar, talking to Ray, putting shit on everybody. He also said, what a fucking change of, looking at the family, and they were over fucking doing the trial. Couldn't have been happier," he said. "Speak to the brother, speak to the younger brother, speak to the older brother. That's what Downer said to me. Look at the brothers. His own office knows what's been going on. This family believes it. They believe their own shit, mate." Television.
I mean, the fact that they made it to air is very interesting.
There were another statement that was called the baggage handler's defence, and those who are in Australia know very well this whole story. It was apparently a defence which sought to lay blame on what had occurred on on baggage handlers. He said that in respect to that baggage handling defence, it's got nothing to do with the case. 3 weeks to put the defence together. I put a defence together. Baggage handlers didn't put drugs in the bags. Nothing to do with it. But now she believes it. They're all fucking believing it. It's not true. That's what I'm saying on national television. That's why you can't put direct evidence. Baggage handlers, because they didn't do it.
Right. So he's lied. He's lied to the court.
In response to the question, he said, "I don't give a shit. You want to fucking attack me? I give you a defence, I take it away. As fast as I give it, I'll take it away." Laughing, "Yeah, sorry about that, guys, you poor buggers. Nah, I won't do it again. Thanks for the defence, though."
So he's put these poor baggage handlers' life through hell.
It's right. It's said to refer to the baggage handlers' defence, presumably address the baggage handlers who were wrongly claimed by him were responsible. Now, the court went on to say, that is said to refer to the baggage handlers' defence, presumably is addressed to the baggage handlers who were wrongly claimed. Now, this is what the court was saying. What is of greater concern in those comments is that he is representing in the information conveyed to the public that the role of the criminal defence is to make up a defence which can be taken away. It is clear when he says, "I give you a defence, I'll take it away." This is certainly likely to bring the legal profession into disrepute with the public. In fact, a person acting as a criminal defence legal practitioner cannot under any circumstances invent facts or invent a defence. To say such a thing is scandalous and is likely to cause the public to lose confidence in not only the legal profession but in the criminal justice system, because it suggests that in a response to a criminal charge that one should do is find a legal practitioner who will make up a defence for an alleged offender. Nothing could be further from the truth.
And in there lies his problems. I know that we've spoken about this before, which is if you don't have any evidence, direct evidence as he's called it there, to prove a defence. So there's nothing, he held no evidence to say that these baggage handlers did it. Then you can only go, your defence, if that's what the defence is going to be, it can only go so far as what we would call putting them to evidence.
Yeah.
Which is to try and create reasonable doubt, but only by attacking their claim, as in making sure that they prove beyond a reasonable doubt, every point at which the drugs passed from Chappelle to the end when the police picked it up.
Yeah, when the bag was open.
The bag was open, and certainly you can ask questions of the police to say, you know, did Chappelle ever have, you know, was there any time when she didn't have control of the bag? And the answer is yes, and that may be reasonable doubt, and it's then up to the prosecution to put forward evidence to say that the baggage handlers didn't put it in there themselves. But that's very different to what he did.
That's right.
Very, very different to what he did. He actually affirmatively stated that these were the people that did it.
And criminalised people who shouldn't have been criminalised on this point.
I mean, it's if we think about it more in some cases which, you know, people know more about, when you think about a murder trial, is to just let's say just give it an example, is if a partner kills their other partner, and your defence is the brother did it.
Yeah.
There's no reason to believe that. There is no evidence to suggest that the brother did it.
Or, you know, somebody came in the middle of the night, broke in.
The boogeyman.
The boogeyman did it. You're absolutely right. I think people think that lawyers lie for a living, and this is a case that shows that we absolutely are not allowed to.
No, absolutely.
We can only deal with the information that's in front of us in a truthful way.
And, you know, it goes further than just this idea that we can somehow bend the truth. It's just not simply the case. It's quite an intricate ethical kind of requirement in many ways.
It is interesting because in the end he was struck off, but it didn't work. Chappelle Corby was still convicted as a drug smuggler in Indonesia and served time for that. So in the end the defence didn't work, but he ended up being struck off.
What about the fact that he was lying to a foreign court?
Look, I think the whole thing, because it says here...
I know he was lying in the court, you know, he was lying in Australia, but it was in relation to a different court matter.
I think it doesn't matter, because they're talking about putting the legal profession in disrepute.
Yeah.
It's not about who he was lying to or the detriment to the baggage handlers as such, although they do tap on that. This is about how we are perceived in the public to administer justice. And
if he's willing to lie blatantly in order to achieve probably more of a personal gain, rather, I know. I just want to know what the end game is. I know if that had worked, Chappelle would have certainly have gotten a personal benefit to that. Yeah. But I suspect that wasn't what this was about. This was about him achieving a personal outcome. It may have been money. Yeah. Because I imagine he got quite a lot of fees from it. There may have been a certain reputational gain if it had have worked. Assume that none of this comes out and as soon as she gets acquitted. But, you know, the idea that someone's able to or willing to lie in order to achieve that goal, lie to a court, whether it be a foreign jurisdiction or not. Well, it's really interesting because he says, you know, the baggage handling defence has got nothing to do with the case. 3 weeks to put a defence together, I put a defence together. So I think you're right, this is about ego. If he had told the lawyers that were instructing them, look dudes, what do you want me to say? I've got no evidence that she didn't do it. There's nothing there. I can't produce something out of nothing. Do you think that that's what the motivator was? His belief that they would have gone somewhere else and they would have paid someone else to do it? I believe so. And what they're failing to do there, and not something that we do, which is to kindly tell the client, let it go. Well, you might lose a lot of money, but you're not losing any money really, because it was never yours to begin with. It was never yours to begin with. Because frankly, that money shouldn't have ever been acquired because there was no defence to put forward. At least not in the way that they did it. And he should have kindly said to his client that this is as far as you can take it ethically. As far as I'm willing to take it. Take it or leave it. If you don't want it, then find a different lawyer. Yeah. And that's completely fine. It's actually what's to be expected. And in fact, this is exactly what the court was saying about this concept where if you can find a lawyer that, you know, you just shop around until you find the lawyer that's going to make up the defence for you. We don't want that in our profession. We want these people to be disbarred because we want them out of the industry. Yeah, and it also, it's, you know, like with any kind of misfeasance, you've got 5% which will do it irrespective of the rules and things like that. And you've got 5% which would never do it, even if it was allowed. But then you've got everyone in the middle. And if you allow a profession which the winners, the lawyers which are doing super successfully are all doing the wrong thing, then of course everyone else is going to follow. And then everyone is doing the same thing.
And then people like us will never even have a law firm because everyone will just shop around for that nasty,
because you won't,
dodgy lawyer.
Because
it works. It actually works. That's the problem. We would all turn into organised crime bosses almost.
Yeah, with the conciliaries or whatever you might find in Godfather.
And what I think, and there are a lot of cases we went through today. I think that the underlying truth on this is that the Commission, when they're prosecuting these claims, is looking for an underlying administration of justice to keep the community feeling that they've got some faith in us, that we're doing the right thing.
Yeah, and it all comes down to that idea of what the society and the profession wants as its lawyers and what they perceive to be fit and proper. And I think with all of those cases, you could kind of point to almost and it's the reason why they were mostly struck off was there's a fundamental flaw in their personality traits.
That's right.
Which is not conducive to being fit and proper. Because instances of doing the wrong thing here and there are not indicative of your personality, but where it is almost the root cause. Take that last case about Chappelle, his root failing.
It wasn't going on TV.
Ego.
It was actually the fact that he did it to begin with. We just found out about it because he couldn't keep his mouth shut. And
his willingness to adhere to ethical codes was only equal to
his getting caught for it.
Well, equal to any kind of personal gain. If the personal gain outweighs that, then he's willing to put the ethics aside.
We quite often have to make hard decisions about the information that's before us, and I have to give tough love to a number of our clients and just tell them the story as I understand it. Yes, there's always wiggle room there. I told a chap today that his case basically doesn't exist, in my view, because of all these problems. But I also say to him, of course I am not the decision maker here. We have seen cases that we thought we were going to lose, that we've won. And we've seen cases that we thought were really laid out, nice and simple, and they've lost. So we're not the decision makers in this, but we are the ones. If a client doesn't come to me because I haven't given them the news that they want, that's fine. I need to be okay with that, and we need to be okay with that as a profession. We're not trying to tell the client what they want to hear in order to gain the fees.
Yeah.
To get the kudos, to get the television appearances.
And isn't it interesting that this might come as a surprise to many of our listeners, but some of the most satisfied clients we've had are the ones which we didn't necessarily give them great news. It was that they clearly saw that we spent considerable time looking into their matter and concluded that they might not have a strong claim or no claim at all. And many of them are completely happy with that as a thing, knowing at least they know.
Yeah.
That they've gotten honest advice.
They're not getting the advice that they want to hear, but they feel like that's the advice that they needed to hear. Yeah. I think you're right. I've done lots of restraints of trade advices over the years, and sometimes I give sad information to someone. Yes, you're exposed. What you did is gonna get you in trouble. And others, I say, no, look, we can. This is the way around it, and it's the truth that they feel comfortable or confident with. It's that, finally I know. Because it's not your parents, it's not your mum, it's not your wife or your friends at the barbecue who are really on board. All aboard the Melanie train.
Yeah, they're on the emotional roller coaster that you're wrong.
They want you to win. They think it's all wrong. They can see you being upset. They've seen you cry and they've seen you get angry, and they want to be on board on the little Melanie train that choo 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 choo. And here I am as a solicitor standing in the way going, nah,
No.
Stop, everyone. Get a bit of realism
Everyone
here.
off the ride.
Everyone off the Melanie train. Let's get moving somewhere else. Yeah, absolutely. But that is our job. And if that means we don't get a client,
so be it.
So be it.
There's always another client. It was one of the best pieces of advice I received when I was first starting, which was, there's always another one.
There's
actually always another client.
And we know about this because we've fired clients before.
There's always another
and
one.
there's always the next client. and that's the way it works. I've said, no, I'm not writing that letter. And the client either stays with us or leaves. I'm still here.
That's going to have to eat.
We're still here. Anyway, everyone, thank you very much. It's a very long podcast. Hopefully you found it quite entertaining. I left the most juicy ones for last. So
No, thank you very much. And
hopefully you've got some insight into how lawyers need to think when we're providing advice and what happens to us when we make the wrong decisions.
Yes, and hopefully we never do.
We never find ourselves in this position. Well, certainly MJTlaw, I think you'd be hard pressed to find yourselves in this position. Yeah.
All right, well, until next time, everyone.
2 more weeks.
This is us at the LawCast.
See you later, and thank you for listening and watching, everyone.
See ya.